Well, it's 7 o'clock. Thursday. Here we go. I hope I pushed all the buttons to get this working. Well. Good evening, Hoosiers. Shock and awe. Yes, you heard me. Shock and awe. How many of you out to feel that way about what's happening today in our constitutional republic? Shock and awe. I know many of you would be saying, this can't be real. This can't be real. These must be old film. Cuba, Venezuela, Chile. It just can't be us. Well, sadly, no. Sadly, no. This is all too real. And it is taking place here in the United States and Indiana. Yeah, Indiana. And you know what? It's only going to get worse. It's only going to get much worse. But Hoosiers, don't despair. Don't freeze with fear. There is a path forward. There is a solution. The Constitution solution. And wouldn't you know, I don't have my Constitution near me, but luckily I've got it all up there. So, hi, I'm Dr. Chris McGarrett from Warsaw, Indiana, here with the other issue of the Constitution solution. Now, I am on a mission to rescue our constitutional republic. And my mission statement is to disseminate the concept that is the sworn duty of every elected office holder and appointed regulatory official to abide 100%, that's right, 100% by the terms and conditions of both U.S. and the Indiana Constitution. How they must do that and how you must judge them is really quite simple. I call it the three-question rule. The three-question rule. Now, this protocol was developed back late 70s and early 80s by the late congressman from Georgia, Dr. Larry McDonald. Wherever there's liberty, you can find a doctor. Here's how it works. When considering any bill, resolution, or regulation, the public official must ask these three questions in this specific order. Number one, is it constitutional? Number two, can we afford it? Number three, do we need it? Do we need it? That specific order. If they don't follow the rule, you are actually we, the people, must note the deviation and ask why. Why are they not abiding by the only function of government? Remember, the only function of government is to secure your God-given natural right, life, liberty, property, and the right to defend those other rights in the best manner that you can. Why? Why? If it is simple, why well over 90%, I'm being generous there, I mean, it's like 97, 90% of government officials in our union fail miserably the three-question test. Why? Why? Sound like an infant there. Why? Well, the answer was given in 1761 by one of our founders, James Otis Jr. He proposed that men oppose liberty for 3 basic reasons: guilt, malice, or folly. And I'm saying guilt, malice, folly. What the heck? Well, allow me to translate into modern American English. Men oppose liberty for 3 basic reasons: pragmatism, malice, or ignorance. Ignorance. That's ignorance of the principles of liberty and our constitutions. Pragmatism, malice, or ignorance. So when you note a politician or if deviating from the constitutions, just sit back and analyze. Just think to yourself, pragmatism, malice, or ignorance. Pragmatism, malice, or ignorance. Or some of the above, or all of the above. Okay. Now that we, the people, have identified individuals and modes, what we do about it? How do we rescue and restore our constitutional representative republic? Well, that's easy. In fact, I have developed an acronym for it. EASSY. Easy. Educate, activate, and reclaim our state sovereignty. Easy. Oh, don't quit my day job. Let the marketing be to professionals. Okay. Educate about the constitutions. Follow my lead. Activate. Don't just sit there and whine and blog at the keyboard. Do something. I have some suggestions if you would like to do something. And lastly, follow the 10th Amendment to the U.S. Constitution and the advice of James Madison in Federalist 46 on how to oppose unconstitutional acts of federal government. And we need to restore state sovereignty as envisioned by the founders. We can call this now Firewall, Indiana. We've made strategic retreat, Firewall, Indiana. And this, Hoosiers, summarizes the mission statement and the goals for the Constitution solution. In the to secure our God-given natural rights and liberties, and storing and rescuing our constitutional representative republic and state. Well, thank you for listening to that. I just thought it would be nice to have my mission statement out there. Now, if you want to move further on this, feel free to private message me, and I will show you how. Now back to the subject at hand, the Indiana Constitution. We have reviewed far in this series Articles 1 through 4, and now we Article 5, the executive branch. Ooh, this will be good. Now remember, Indiana has had 2 constitutions. The first in 1816, when it became a state, and the second and current, although amended one, from 1851. Article 5, which was actually Article 4, in 1816, contained 26 sections, and Article 5 in 1850 contained 24 sections. Let me tell you that the 1816 one was more straightforward in its construction. Remember that I state that historical documents need to be understood in their temporal context. Yes. So there is available online a Constitution of the State of Indiana annotated by a gentleman named Andy Horning. That's Horning. Andy is a lover of liberty and constitutions. And he lives in a place aptly called Freedom, Indiana. He published this annotated version 2010, and it contains historical and other comments. I will be using his document to discuss Article 5, the executive. Here we go. This is his annotated in the Indiana Constitution. Not this too dry and dull, but you have to know it. You're living here. We're trying to save it. So pay attention. Section 1. The executive power of the shall be vested in a governor. He shall hold his office 4 years and shall not be eligible more than 8 years in any 12 years. On the 1816 Constitution, 6 out of 9 years. They used to have 3-year terms. Section 2, there shall be a lieutenant who shall hold office during 4 years. Section 3, the governor and lieutenant governor shall be elected at the times and the places of choosing members of the General Assembly. Section 4, each candidate for lieutenant governor shall run jointly in the general election with a candidate for governor. And his name shall, excuse me, not COVID. His name shall appear jointly on the ballot with the candidate for governor. Each vote cast a candidate for governor shall be considered for the candidate for lieutenant governor as well. The candidate for lieutenant governor whose name appears on the ballot with that of the successful candidate for governor shall be elected lieutenant governor. One of Andy's comments. Originally, the elections of governor and lieutenant governor were separate, just like in the U.S. Constitution for president and vice president. There were many good reasons for this, and Andy won't go into them now. But consider that the two weren't necessary from the same party, let alone chose a team. So just think about that and we'll get a better idea of how politics works. And Andy goes on to say, I think it's a terrible shame these offices have become so partisan and conjoined. Okay, Section 5. In the event of a tie, the governor and lieutenant governor shall be elected from the candidate receiving the tie vote by the affirmative vote in joint session of a majority of the combined membership of both houses as the first order of business after their organization. Okay. Section 6. Contested election for governor and lieutenant governor shall be determined by the General Assembly in such manner as be prescribed by law. Contested elections. Have we ever had one of those? Let me think. Section 7. No person shall be eligible to the office of governor or lieutenant governor shall not have been 5 years as a citizen of the United States and also a resident of the state of Indiana during the 5 years next preceding his election. Nor shall any person be eligible either of the said offices who shall have attained the age of 30 years. Okay. Section 8. No member of Congress or person holding any office under the United States or under this state shall fill the office of governor, lieutenant governor. Section 9. The official term for the governor and lieutenant governor shall commence on the second Monday, January, in the year 1853, on the same day, every fourth year thereafter. Section 10. This is ongoing, full of technicality. We'll get through it. These are all important. Section 10A. In case the governor-elect fails to assume office, or in case of the death or resignation of the governor or the governor's removal from office, governor removal from office, the lieutenant shall become governor and hold office for the unexpired term of the person whom the lieutenant governor succeeds. In case the governor is unable to discharge the powers and duties of office, the lieutenant governor shall discharge the powers and duties of the office as acting governor. Section 10B. Whenever there is a vacancy in the office of lieutenant governor, the governor shall nominate a lieutenant governor who shall take office upon confirmation by a majority vote House of the General Assembly and hold office for the unexpired term of the previous lieutenant governor. Now, I'm keeping track of the powers attributed to the governor. That was number one. I'll sum it up at the end. Power number two. If General Assembly is not in session, the governor shall call it into special session to receive and act upon the governor's nomination. In the event of the inability of the lieutenant governor to discharge the powers and duties of the General Assembly may provide by law for the manner in which a person shall be selected to act in the lieutenant governor's place, declare which powers and duties of the office such person shall discharge. Section C. Whenever the governor transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives, the governor's written declaration that the governor is unable to discharge the powers and duties of the office until the governor transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the lieutenant governor as acting governor. Thereafter, when the governor transmits to the president pro tempore of the Senate and the Speaker of the House of Representatives the governor's written declaration that no inability exists, the governor resume the powers and duties of the office. I don't know, this is dry and boring, but you have it. It's just like in the U.S. Constitution. D. Whenever the president pro temp of the Senate and the Speaker of the House of Representatives file with the Supreme Court a written statement suggests that the governor is unable to discharge the powers and duties of the office, the Supreme Court shall within 48 hours to decide the question, and such decision shall be final. Thereafter, whenever the governor files with the Supreme Court the governor's declaration that no inability exists, the Supreme Court shall meet in 48 hours to decide whether such be the case, and such decision shall be final. Upon a decision that no inability exists, the governor shall resume the powers and duties of the office. All sounds very confrontational. Section E, or Clause E. Whenever there is a vacancy in both the office of governor and lieutenant governor, the General Assembly shall convene joint session 48 hours after each occurrence, elect a governor from and of the same political party as the immediately governor by a majority vote of each house. If either house, the General Assembly is unable to assemble a quorum of its members because of vacancies in membership of that house, the General Assembly shall convene not later than 48 hours after a sufficient number of vacancies are filled to provide a quorum of members of that house. Clause F. An individual holding one of the offices shall discharge the powers and duties of governor if the office of governor and the office of lieutenant governor are both vacant in the order listed. This sounds like a designated survivor clause. 1. The next in line would be, are you ready? The Speaker of the House of Representatives. Number 2, the President pro temp of the Senate, if the office described in subdivision 1 is vacant. 3, the Treasurer of the state, if the offices described in subdivisions 1 and 2 are vacant. 4, the auditor of this, if the office is described in subdivisions 1 through 3 are vacant. 5, the Secretary of State, if offices described in subdivisions 1 through 4 are vacant. 6, the State Superintendent of Public Instruction, if the offices described in subdivisions 1 through 5 are vacant. That is a designated survivor clause. B, an individual authority discharge the governor's powers and duties under subsection F, and the General Assembly fills the office of governor under this section. That was amended both in 1970 and 2004. Now, Andy Horning comments here, the preceding became laughably complicated and much less clear than the original's single sentence. Back in 1816, it was simple. Things were simpler back then. Section 12, the third part. The governor shall be commander-in-chief of the armed forces and may allow such forces to execute the law, to suppress insurrection, or to repel invasion. Got that? The governor shall be commander-in-chief of the armed forces and may call out such forces to execute the laws, or to suppress insurrection, or to repel invasion. Don't see anything there about wearing masks or closing pizza parlors. That's just my interpretation. And again, Andy has to say, Commander-in-Chief of the Armed Forces. This is clearly not what we've been taught since the federal government unconstitutionally stole so much power from the states with the 1903 Dick Act. Let's look that up. That was actual person. This is what the 1816 Constitution said of the governor's role as commander-in-chief. He shall be commander-in-chief of the army and navy of the state and of the militia there, except when they shall be called into service of the United States, but he shall not command personally in the field unless he shall advise so to do by resolution of the General Assembly. All right. Section 13. The governor shall, from time to time, give the General Assembly information touching the Constitution of the state and reckon such measures as he shall judge to be expedient. I'd call that a power. That's number. Section 14. Every bill which shall have passed the General Assembly shall be presented to the governor. The governor shall have 7 days after the day of present to act upon such a bill as follows. So this is the power of the governor. 1, he may sign it, in which event shall become law. 2, he may veto it. A, in the event of a veto General Assembly session, he shall return such bill with his objections within 7 days of present to the House and originated. If the governor does not return the bill within 7 days of present, the bill becomes law, notwithstanding the veto. B, if the governor returns the bill under clause A, the House in which the bill originated shall enter the governor's objections at large upon its journals and see to reconsider and vote upon whether to approve bill. Bill must be reconsidered and voted upon within the time set in clause C, which we haven't got to. If after such reconsideration vote, majority of all members elected to that house shall approve the bill, it shall be sent with governor's objections to the other house, by which it shall likewise be considered and voted upon, and if approved by a majority of the members elected to that house, it shall become law. Section C. If the governor turns a bill under clause A, the General Assembly shall reconsider vote upon the bill before the final judgment of the next regular session of the General Assembly that follows the regular or special session in which the bill was already passed. If the House in which the bill originated does not approve the bill under Clause B, the other House is not required to reconsider and vote upon the approval of the bill. If, after voting, either House fails to approve the bill within this time, the veto is sustained. D. In the event of a veto after final judgment of a session of the General Assembly, bills shall be returned by the governor to the House in which it originated on the first day General Assembly is in session after such adjournment. The House shall proceed in the same manner as with a bill vetoed before adjournment. Bill must be reconsidered and voted upon within the time frame set out in Clause C. If such bill is not so returned, it shall be a law notwithstanding such a veto. Section 3. He may refuse to sign or veto a bill, in which event it shall be law without his signature on the 8th day after presentment to the governor. Little b. Every bill presented to the governor which is signed by him or on which he is to act within 7 days after presentment shall be filed with the Secretary of State within 10 days of presentment. The failure to so file shall not prevent bill from becoming law. And little c, in the event a bill is passed over the governor's veto, such bill shall be filed with the Secretary of State without further present to the governor, provided that in the event of such passage over the governor's veto and then the next meeting General Assembly that shall be deemed to have been the action of General Assembly which initially passed the bill. Well, it was amended in 1972 and 1990, and believe me, I read an 1816 Constitution, much simpler. And you wonder why things are confused. Well, Section 15, another power. I believe this is Power 6. The governor shall transact all necessary business with the officers of government and may require information and writing officers of the administrative department upon any subject relating to the duties of the respective office. Section 16, this is another power. I think it's number 7. The governor shall take care that the laws are faithfully executed. Elegant but simple. The governor shall take care that the laws are faithfully executed. Faithfully. If General Assembly said something, that something that he's to execute, not make it up. A Horning has a comment that says, there it is, the governor's job description. When are you going to elect somebody who will actually do it? Section 17. This is the 8th power. The governor may grant reprieves, commutations, and pardons after conviction for all offenses except treason and cases of impeachment, to the regulations as may be provided by law. Upon conviction treason, the governor may suspend the execution of the sentence until the case has been reported to the General Assembly at its next meeting, when the General Assembly shall either grant a pardon, commute the sentence, direct the execution of the sentence, or grant a further reprieve. Coming up now with power number 9, same section. The governor may remit fine forfeiture under such regulations as may be provided by law, and shall read the General Assembly at its next meeting each case of reprieve, commutation, pardon granted, and also the names of all persons in whose favor remission of fine forfeitures were made and the several amounts remitted. Provided, however, the General Assembly may, by law, constitute a council composed of officers of state, without whose advice and consent the governor may not grant pardon in any case except those left to his sole power by law. Sounds like he got some powers, but the General Assembly may take away. You have to read the section of code. And Andy warning comments here. Constitutional governor give countless Hoosiers houses back. People in prisons and illegal would be freed. Monies would be returned. Rights would, of course, be restored. As unconstitutional agencies, practices, rules, laws would be nullified. Justice would be done. Why wouldn't you do that? Why don't we vote for that? Section 18, power number 10. When a recess of the General Assembly, a vacancy shall happen in any office, the appointment to which is vested in the General Assembly, or at any time a vacancy shall have occurred in other state office, or in the office of judge of any court, the governor shall fill such vacancy by appointment, which shall expire when a successor shall have been elected and qualified. Section 19 was repealed in 1980. What was Section 19? Well, it was a section. It was a power, actually, that the governor would issue writs of election when offices needed to be. So that was repealed. Section 20, power number 11. Should the seat of government become dangerous from disease or a common enemy, the governor may convene a General Assembly at any other place. Section 21. Now we're getting to the lieutenant governor. The lieutenant governor shall, by virtue of his office, be president of the Senate, have a right, when in committee of the whole, to join in debate and to vote on all subjects, and whenever the Senate shall be equal-divided, he shall give the cast vote. And he goes on to comment, the president of the Senate is a very important role. There's a direct link between lawmaking and law execution and enforcement. This job is far more important, in fact, than what most people think the lieutenant governor is supposed to do. And this is the only office of the Indiana General Assembly that cannot be chosen by the assembly members themselves, Speaker and President pro tem, majority leaders. The term pro tempore means essentially for the time being, because the Indiana Senate President pro tem is not the president of the Senate. The actual legislative duties of the Senate's President pro tem are not defined in the Constitution, but the intent was that there wasn't much of a role at all when the lieutenant governor was president. So today, the Senate President pro tem has too much power. That was Andy's comment. Section 22. The governor shall at stated times receive for his services compensation, which shall neither be increased nor diminished during the term for which he shall have been elected. Section 23, compensation of the lieutenant governor. The lieutenant governor, while he shall act president of the Senate, shall receive for his services the same compensation as the Speaker of the House of Representatives. And any person acting as governor shall receive the compensation attached to the office of governor. Section 24, we're coming to the end. Neither the governor and lieutenant governor shall be eligible to any other office during the term for which he shall have been elected. And you're sticking with that. That is your 851 plus recent amendment Constitution, Indiana, on the executive branch. Now, in fact, I counted 11 powers of the governor. Maybe you could quibble about the other things, but I counted 11. Now, I didn't hear anything in there about mandating mask wearing, closing businesses, restricting the right of assembly or travel. I didn't hear anything in there about those things. So you could postulate that perhaps there's some unconstitutional action going here. Now remember, just like with the U.S. Congress, they cannot delegate away their powers to the executive. that usurpation. That, according to the founders, was not allowed. Well, that completes Article 5, the executive. In the next section, we'll be discussing on May 27th, that's May 27th, Thursday, 7 p.m., Facebook and YouTube. The subject will be Article 6, the judicial branch, or as they used to call it, the weakest branch. But we now know that it is not true. The oligarchs in black robes think they rule us. So we'll go over Article 6, judicial, next time. And that's, let me tell you, you better some coffee for that, because that's a real dry one. Okay, well, until those years, remember doctor's orders, wash your hands, don't touch your face, but above all, keep your distance. Keep your distance from those socialists, statists, globalists, collectivists, politicians, bureaucrats, because now, Hoosier, you know exactly who they are. They can't hide behind the curtain anymore. Well, good night, everyone. And as they say, each episode of the ABS Constitution Corner, don't just know your Constitution, live it. Good night.